So what would the standard be? Is it like an intelligible principle of money spent? I mean, I think we're all struggling to figure out then what's the standard that you would use? Just assuming that you're right, that there has to be something more than the $600 million. How do you decide how much is too much or how specific is specific enough?
So Your Honor, I think that at the back end, it's difficult to come up with a hard and fast rule that's saying too much is too much, which is why I do think you need to look at it from the front end and ask, has Congress made a determination as to what the amount should be, or has it delegated that fundamental determination to the executive branch? And I think it's far worse.
In doing that, don't we have to assume that that's what the Constitution requires of Congress? That's where I'm getting hung up. That you keep saying Congress is delegating this authority, and we understand your argument with respect to it, but what if that's not the sort of content of the authority? What if Congress doesn't have to?
Well, Your Honor, if that's your position, I don't think I can get your vote. But I think if you step back and you understand that the Appropriations Clause is meant to separate the power of the sword from the purse, then it has to be a starting point that Congress can't simply say to the executive, you know, you pick the amount. We're not going to pick it. You pick it, which is why I think when you look at this language, at a minimum, Congress has to pick the amount.
Mr. Francisco, I was hoping you might finish your answer to Justice Barrett.
Sure, and with respect, Justice Barrett, with respect to your question, when it comes to delegation, I think it's particularly problematic with respect to the Appropriations Clause. Remember, the Appropriations Clause isn't in Section 8 of Article 1, it's in Section 9 of Article 1. So it is both it is not just a privilege of Congress, it's an obligation and a duty that Congress has to check the executive branch. And if it can simply transfer to the executive its duty to check the executive, you are unifying the sword and purse. So to the extent that there's any delegation allowed in the context of setting the amount of the appropriation, it's got to be a very narrow one. And that is a perfect explanation for the founding era sums not exceeding statutes. Those were statutes where Congress, in an annual appropriation, fixed the amount that it thought that the government should be spending based on Hamilton's detailed estimates, often down to the penny. They just simply recognized a margin of error. And if Congress got it wrong in one year, it could fix it in the next year. That is, again, why I think that this unique constellation of factors is so uniquely problematic.
But you concede that standing appropriations aren't per se unconstitutional. So you're saying Congress could fix it in the next year. But how long before a standing appropriation becomes a problem?
Sure, Your Honor. I would not concede that a long-term standing appropriation would be constitutional. I think non-delegation principles generally recognize some play in the joints. I actually think it would be problematic to simply delegate to the executive for 1 year to pick its own number within a broad band of discretion. But I don't have to defend that position, because here we've got the entire opposite end of the spectrum. This is a perpetual delegation to pick your own number within a very broad range of discretion.